You're watching the Florida Channel, a public service of the Florida Legislature, WFSU-TV, and Florida State University.
All rise. Hear ye, hear ye, hear ye. Supreme Court of Florida is now in session. All who have cause to plead, draw near, give attention. You shall be heard. God save these United States, great state of Florida, and this honorable court. Ladies and gentlemen, Supreme Court of Florida, please be seated.
Welcome to the Florida Supreme Court. Justice Periente will not be here today. She cannot be here, but will be observing oral argument and still participate in the cases today. The first case is Jennings versus State of Florida.
Good morning. May it please the Court. My name is Paul Callow. I represent the appellant Brandy Jennings on this appeal of the denial of his Rule 3.851 motion for post-conviction relief. I'd like to concentrate this morning on the claim of ineffective assistance of counsel at the penalty phase. After the evidentiary hearing in this case, counsel testified that he made a decision not to present mental health mitigation or other mitigation in lieu of presenting good character traits of Mr. Jennings. And I submit that that decision is unreasonable given the fact that counsel did not perform in anywhere close to a constitutionally reasonable investigation.
Well, he did have expert, right?
He did.
And are you concerned because of just the way that the motion or order was entered with regard to what that expert was going to do? When I thought that there may have been a little bit difference there, but in actuality, did the expert really do both the competency and mitigation, and I mean, really a lot of testimony about that?
Well, there are a couple of issues there. Firstly, yes, the order appointing the experts didn't specifically mention that they were being appointed to address penalty phase.
Is that required, though?
Well, I don't know that it is required, but if you look at what the experts actually did, they didn't do what would ordinarily be considered part of a penalty phase investigation.
What did they miss?
Well, first of all, they weren't provided with and they didn't seek adequate records.
What records did they miss?
They didn't have any school records from Mr. Jennings' childhood until he had moved to Florida at the age of 14 or 15. So all the school records they didn't have. More importantly, though...
And what are the missing school records, and what did they show with regard to mitigating circumstances here?
Well, they showed several things, not only with regard to mitigating circumstances, but also things that should have led counsel to investigate further with regard to Mr. Jennings' mother.
What?
Okay.
What?
First of all, the school records showed that Mr. Jennings had a rather troubled school history. He had what we later find out is learning disabilities, but the school records themselves show that he did not do very well in school. He had reading deficits. He had deficits in math. They also show that he attended at least six different schools by the time he was in 6th grade. If I'm recalling that number correctly, he attended a number of schools before even reaching middle school.
Was that because his mother moved around a lot?
Yes.
Did that have to do with his mental condition? The reason they moved?
Well, just the fact that he attended so many schools shows what a chaotic environment he grew up in. The fact that the school records do demonstrate that the mother was moving him around from state to state, but they also show that the substance of the work that he was doing in school was subpar. And that
he had bad grades. That's what you said.
He had bad grades, and specifically he had difficulties in specific areas.
And did any of those records demonstrate that he had been tested in any way for having difficulties, or what his IQ was at that time, or any of those things?
My recollection is that they demonstrated that he got poor grades.
That's okay.
Okay.
Well, I mean, that means that answers no to her question then.
To the best of my recollection, yes. Right. It answers no. But I think the school records also demonstrate that counsel's decision to rely on the mother to present evidence that Mr. Jennings was this ideal son who got great grades in school, got straight A's, was unreasonable. Had counsel obtained these records, he would have realized that this is not really the case. There's more investigation that needs to be done here.
Was there any indication that counsel knew that the family had moved around a lot? Because that's how you go to 6 different schools, is you move, and I think that happens to a lot of more than we think. There was
an indication of that, and it was testified to by the mother. But again, it was also testified to that, where the mother testified that he was a straight A student and that he functioned well, and that's hardly mitigating, and it's certainly not accurate. It doesn't give an accurate depiction of his experiences growing up. But going back to the original question about additional records that the experts didn't have, the other very significant ones are the medical records, which demonstrate that at the age of 8 months to 2 years, Mr. Jennings had between 15 and 20 febrile convulsions.
And what did that produce?
Dr. Hyde testified at the evidentiary hearing that created neurological deficits later on in life.
Were there neurological deficits, or was that a subject of dispute?
Specifically with regard to neurological deficits, there weren't. There were.
Okay, well, see, I mean, I have a great appreciation for a person who had this terrible background. But what troubles me in this case, this is almost like a Monday morning quarterbacking, is that I've found experts that'll say things just a little differently, and that's what we're dealing with here. That seems to me what we're talking about in this case.
I respectfully disagree with you there.
I expected you would.
Okay.
So that's why we would need you to help us tell us why that's wrong.
And I appreciate it. The reason that this is not merely just questioning trial counsel's decision here is that I think it's clear from the testimony and the reports of the doctors that are in evidence, the trial penalty phase doctors. They weren't provided with adequate information. They never did the kind of investigation that is required, and certainly was required in the mid-'90s, in a death penalty case of this magnitude, to investigate family members, to investigate friends. These are the kinds of information, obtain records, provide it to the experts. These are the types of investigation that needed to be performed.
Didn't the defense attorney testify there were two other attorneys that assisted him at various points?
There was one.
Okay. And was there an investigator?
There was the investigator from the public defender's office.
And what did the investigator from the public defender's office do?
Well, according to trial counsel, he went around in the Southwest Florida area, and talked to people to gain whatever might be mitigating information. And trial counsel testified to this at the evidentiary hearing and was not very specific about it, because I think it's very clear that the investigator really didn't do the kind of investigation that would be expected. He didn't travel outside the state of Florida, and given the fact that Mr. Jennings had grown up in all of these western states, Colorado, Wyoming, Oregon, there was information that should have been obtained from these other states. It appears to me, from what trial counsel had testified to, that the investigator just sort of went around and talked to the mother, who was local, and talked to a few friends who turned out to be almost as aggravating in their testimony as they were mitigating. And there were people that were available, as we demonstrated at the evidentiary hearing, who could have given detailed testimony about the squalor, the poverty, the chaos that Mr. Jennings grew up in, that simply just weren't discovered and were available. Instead, trial counsel went with the local friends who only knew Mr. Jennings as a teenager later in life, and their testimony turned out to be almost as aggravating, or probably more aggravating than it was mitigating, because these people were effectively cross-examined by the state. Specifically Mary Hamler testified that Mr. Jennings was good with children, good with her children. Trial counsel completely overlooked the fact that Mary Hamler testified almost against Mr. Jennings in the co-defendant's trial. So it seems as though trial counsel...
Did she testify against him in this trial?
Well, she testified at the penalty phase as a penalty phase witness, but then on cross-examination, the state elicited more damaging...
Well, isn't that what this strategy is all about? I mean, it's a sort of double-edged sword?
It didn't have to be.
If you do it, down if you don't?
No, because he didn't have to make that decision. There were people who could have testified to the same things that the penalty phase witnesses did testify to, who would not have been as damaging on cross-examination.
Then this trial counsel said he's worked with these two experts many, many years. They knew what to look for in terms of mitigation, very experienced in death penalty cases. He knew what to look for, and he made those strategic decisions based on that, his experience.
That was his testimony, that he had worked with these experts before. And I submit to you that I have never worked on any other cases, and I wouldn't go there with the court with these experts. But I would say that the investigation that they conducted, and let me be clear, we're talking about an investigation that's conducted by an expert, for example, a mitigation expert, as opposed to merely a mental health diagnosis. And it seems as though the experts were concentrating more on a mental health diagnosis without doing the kind of detailed investigation of the defendant's background. Outside of any diagnoses, numbers, these sorts of things. I mean, that's very important, but what was available was this additional mitigating information that didn't necessarily go to a specific diagnosis. So these experts may have been very effective in doing an evaluation for the purposes of a psychiatric or psychological evaluation for a diagnosis, but they didn't conduct any of the investigation that would have been required.
Was the defense counsel ever asked about these witnesses that you now presented at the evidentiary hearing?
At the evidentiary hearing where they asked...
Was the defense attorney ever asked about these witnesses that you now present at the evidentiary hearing?
He was asked if he investigated or contacted any witnesses outside of the state of Florida or the local area, and he said that he hadn't, if that answers the question. There was another witness, Heather Johnson, that defense counsel was in touch with through the investigator only by writing a letter asking for any good word that she could provide. And that was the extent of that investigation. Nobody contacted her again. She wrote a letter in response. All of that's in evidence. And nobody contacted her again. And she had, if the trial counsel was going to go with a good character defense for mitigation, he could have gone with people like Heather Johnson, who wouldn't have been as susceptible to the bad information that came out with the trial witnesses. There were additional witnesses who who couldn't have been as effectively cross-examined, and who could have provided as compelling, or if not much more compelling, mitigation testimony than those at the trial. If there are no other questions, I'll reserve the rest of my time for rebuttal.
Thank you.
Thank you.
Good morning, Your Honors. May it please the Court. I'm Carol Dittmar from the Attorney General's Office representing the appellee of the state of Florida. With regard to the mental mitigation, there were two doctors who were appointed, Dr. Wald and Dr. Masterson. Dr. Wald was a psychiatrist brought in initially. He asked that Dr. Masterson be brought into the case and do psychological testing. So that was done. If you read the reports that they compiled at the time, they are full of Mr. Jennings' personal history. They relate his medical background, they relate his social background, and although the experts may not have had as many resources as the post-conviction experts were given, they certainly had plenty of information, background information about Mr. Jennings, and Jennings has not identified anything in their report that was inaccurate or is somehow contradicted by the records which he has now presented about his earlier childhood school records. The main thing he's getting...
Let me ask you this. They say that in the earlier records, it demonstrates basically that he has somewhat of a a childhood that was chaotic.
Moving around.
Chaotic,
yes.
That's the word I was looking for. And that he moved around a lot, and this demonstrates that he wasn't the good student that his mother had testified that he was. And so why shouldn't there have been some gathering of that kind of information so that those mental health experts that the defense did have would have a more complete background?
Well, they certainly had that information from Jennings, and actually the mother...
Jennings told the experts?
Absolutely. They had a great deal of self-report of his history, which, again, has not been contradicted by anything now that the records, actually the documented records now support his history as he gave it to the experts. There's nothing that's contradictory there. And the mother, of course, testified about that chaotic background in the penalty phase to the jury. And so the jury heard all about his moving around and knew that he had a chaotic background. The fact that she, as a mother, turns him into a straight-A student, yes, that's contradicted by the records. I don't think that's anything critical. I think that juries probably wouldn't be surprised by that. He did have A's. He had some good grades and some bad grades. It was very mixed. Some things he did well in and some things he didn't. He has a very high IQ, but he, according to Dr. Eisenstein, he does have a learning disability, which is where Dr. Eisenstein gets the statutory mental mitigation. The reasons that Tom Osteen, the defense attorney, laid out for not presenting the mental health experts, Dr. Wald and Dr. Masterson, are supported by the record and are certainly very reasonable grounds to not present this testimony. One thing was he considered that they really didn't have anything very persuasive in the way of mental mitigation. They didn't have any type of major mental illness. Well, let me ask you this. Did they do any kind of neurological testing? Because it seems to me that the new experts now say he had some kind of brain injuries, that there was some kind of multiple traumas at some point. No, actually, Dr. Thomas Hyde, was the neurologist that was presented at the post-conviction hearing, the evidentiary hearing, and he really doesn't come up with, he says because of the histories of febrile convulsions when Jennings was a small child, even an infant, puts him at a risk for having other neurological deficits, but in his testing, he didn't find any neurological deficits, and he couldn't find anything significant in the testing that he did of Jennings. So,
was there a PET scan? I thought there was a PET scan here. No,
I don't believe they ever had a PET scan. No, and there was no evidence of brain injury or brain damage or any neurological deficits, just the history of having a risk for that. So Dr. Hyde did not give either one of the statutory mental mitigators. Faye Sultan was another post-conviction mental health expert. She did not find that either of the mental mitigating statutory mental mitigators would apply in this case. The only post-conviction expert that even gives him that is Dr. Eisenstein, relying on a diagnosis that he's gifted and learning disabled. And he says the reason that's extreme is somebody could have done something about it in the past and no one ever did. So that's where he finds the extreme disturbance, which I don't think is a very persuasive statutory mitigator if that's the testimony that you're going to present. His other diagnosis was that Jennings has intermittent explosive disorder, and yet the records and the testimony from the lay witnesses don't really support that because he doesn't have a history of violence or aggression, which you would see with someone typically that has that kind of disorder. Again, that's not a major mental illness, but that's what Dr. Eisenstein used to get the second mental mitigator in there. Now, one of the other reasons that Tom Osteen did not want to present these witnesses is that in addition to not really getting any strong mitigation, he would have to sacrifice, most notably in this case, the no significant criminal history statutory mitigator, which was argued and found low and weighed in the sentencing order. And yet, if these mental health experts had testified, they were fully aware that Jennings did have pretty extensive criminal activities. He didn't have a lot of convictions, and they weren't necessarily violent crimes, although one was an attempted armed robbery. But for the most part, everyone suspected maybe he was using drugs at the time, but he tells the experts he was actually buying and selling and making a lot of drug deals. He was he says, ripping off money from corporations. He was doing illegal street racing. So there's a lot of criminal activity that would have defeated the statutory mitigator of no significant criminal history. He would have lost that. So he really would have ended up with less mitigation if he had gone the route of presenting the mental health experts, who at the time found that Jennings was a sociopath. So that's the testimony that was available to the trial attorneys. In terms of the...
Ms. Dittmar?
Yes, sir.
As an officer of the state, an officer of the court, where should we be looking at some of the new stuff that came out during the post-conviction proceeding as the most significant, or the one that would deserve some discussion or some analysis? Because there were some that came out and...
Well, I'm kind of at a loss because I think Eisenstein gives them the strongest testimony they can give, but I think his testimony is very weak on the facts of these cases, because not only is it not supported by the lack of a violent, aggressive history, but
that's where you would find at least some new stuff.
I think that's the strongest they presented in post-conviction was Dr. Eisenstein was their strongest witness. One of the other things that he says, which I think any fact finder would find incredible, is that these were unplanned and reactive murders. And this is a case where, this court recalls in direct appeal, you affirmed the CCP aggravating factor. So these weren't reactive, unplanned murders. And that really isn't supported by anything. It's not supported by the record. It's not supported by what Jennings told Eisenstein.
But this goes along with the explosive personality.
Right. He was trying to come up with a way to fit that in, and it really just doesn't. And even Dr. Sultan said, well, I could see labeling him with that diagnosis, but even she couldn't see how it could have possibly affected anything about this crime.
Well, how about his running battle with the other waitresses and workers, employees there? Does that hook together in any way?
Well, he really didn't. There wasn't anything about that came out in post-conviction.
It's there. It's in the record. I mean, that he detested some of the others. Isn't this the case?
That was in the trial record.
Well, I understand, but that's part of this case.
Sure.
So, I mean, that doesn't hook together in some way?
Well, I think that
this was more provoked. This was more provoked by that relationship than anything else. Is what I'm getting the tenor or flavor out of this on. Not
really. I mean, these murders were really just done to facilitate the robbery and to eliminate the witnesses to the robbery. It was a very very carefully planned out because they know it was a very short time frame. It was a 10-minute time frame where Jennings and Graves went in, got the 3 victims, put them in the freezer, killed the victims, gathered all of the proceeds of the robbery, and took out the back door in 10 minutes. So it was very.
And did Jennings go in with gloves but with no mask?
Gloves and no mask, yes. And they had the masks in the truck, but they didn't use the mask. And obviously, both of them had worked in this same restaurant. They were known to the employees. There was some personal animosity between Jennings and Dorothy Siddle, who was the assistant manager who had fired him. I don't think there was anything in the record about his relationship with the other 2 victims. But there was animosity, and in fact, it appears that she was more brutally attacked than the other 2. So those kind of fit together in that sense. But it really doesn't fit in with supporting anything that Dr. Eisenstein said about the way that the murders occurred. So if you look at the mental mitigation, that was a completely reasonable decision, and there was full investigation there with both of the experts having the history. The other thing about the history is there was some effort, and it's well documented through trial counsel as well as the expert reports, that they did try to get Tawny Jennings, the mother, to go meet with the experts, and she never did that. She made appointments a couple of times that she didn't follow through, but to the extent, and the defense attorney and the investigator were trying to facilitate that, coordinating that effort to get her in to see the doctor, and she just failed to follow through with that. So she did meet with with one of the post-conviction experts, but that was something that, again, trial counsel made every effort, did everything they could, and it just didn't happen. So you can't really fault trial counsel now for things that were beyond his control when he was making the effort to get things done. As far as the other family background and history,
is it true that this record will demonstrate that the trial counsel never looked at anything before, I guess, he moved to Florida at age 13?
No, that's not true. First of all, they had the mother who knew his whole history and was able to give his whole history.
The mother.
But in terms of investigating beyond the mother, what Osteen testified to, and the record site that I had for this in my brief is volume 15, 2893 to 94, that he had, while he did not speak with other family members and he didn't remember traveling to Oregon, that he had corresponded in writing with other people in that area. So he had corresponded with Oregon people. He had also, we know, corresponded in writing with Heather Johnson, who I believe was in Maryland or Virginia, or had left the state of Florida by the time he's corresponding with her. So he is writing letters out of state. He's trying to get with people, and his investigator is trying to follow up with these people. He did not want to put Heather Johnson on as a witness because when she wrote him back, she said she thought the robbery, she could understand his frustration and that she thought he was a robber. And so he didn't want to put on a witness that was going to say, you know, it's understandable that he would rob this Cracker Barrel. He didn't think that would go over very well with the jury, and understandably, that's a reasonable decision. So he didn't want to put on, and as far as the other witnesses, similar witnesses at the evidentiary hearing, they really just pretty much repeated what the same witnesses had testified to at penalty phase in terms of Jennings had a good work history. He was good with children. He was a nice guy. He took care of his mother.
I guess two of the things that struck me from the new witnesses is, one is about how chaotic the house was that they lived in, and the other was that there was some suggestion of incest in the family. And so
from
was
Patricia
any of that
Scudder,
information?
who is Tawny Jennings' cousin from Oregon, she testified that on 3 different occasions for about a week each time, she went to the house where Jennings lived with his mother and helped take care of them because the mother was either recovering from surgery or had had health issues and needed some help. And the mother actually had called her and said, you know, I'm having these issues. Will you come help me take care of the house and help me take care of my son, a dog, a pet, or something? So she talked about those times that she went into the house and that it was messy and cluttered and unsanitary. But she also said that other than those 3 one-week periods, she never really had any contact with the family. She didn't go to the house. She didn't see. So she didn't know if that's how it was most of the time, or if it's just it was in bad shape because the mother was having physical problems at that time or recovering from surgery or having a particular incident that caused the house to be messy at that time. So I don't think her testimony should be, she didn't have the knowledge to be able to say what the house was like in other than those limited incidents that she had seen it. And she certainly, she knew that the family moved around a lot, but other than saying they moved around a lot, which the mother had already said, she really didn't offer anything else on that. So there isn't much that comes from the cousin, and in some ways, Patricia and then her husband also testified, and in some ways their testimony is a little inconsistent. And it's not clear whether you would put that on instead of putting on Tawny Jennings, who obviously had a great deal of information about her son. I don't think it would have been a good penalty phase strategy to not put on the mother and just go with the cousin that really didn't have a lot of information but could say bad things about the mother. But apparently, you know, we're looking now on post-conviction. That's a different tack that I guess they could have taken in hindsight. But I think the case that they put on in penalty phase is the strongest mitigation case that's been presented and is much stronger than the mitigation case, for, if you will, that was put on in post-conviction. And that's pretty much what the circuit court concluded when it denied relief. It found that there was no showing of deficient performance and no showing of prejudice in a very thorough order. And I think if this court especially reads the expert reports that were prepared for trial and the trial attorney's testimony, there's full support for all of the court's findings in rejecting this claim. So for that reason, I would ask this court to affirm the denial of post-conviction relief and deny the habeas petition. Thank you.
Thank you. Rebuttal?
State didn't mention the detailed testimony that was presented by the other expert, Dr. Sultan, who had interviewed the mother, Mrs. Jennings. And while the state would say, or has said, that she had the most information or had a lot of information about her son, that's certainly not shown in the record. Her testimony was a few pages. Much of it was inaccurate. Much of it was she couldn't remember. Mr. Jennings grew up in an extremely chaotic environment. The fact that Mrs. Scudder only recalled being at the Jennings home or Tawny Jennings home on a couple of occasions, and that maybe somehow his childhood, other than those few occasions when Miss Jennings was ill, was somehow idyllic or not as bad, is just, it's unreasonable to think that. Mrs. Jennings testified at the trial that she had health problems her entire life, and that was the lifestyle that he was raised in. I think that that's really the only reasonable interpretation you can get from the evidence that was presented. Dr. Sultan also testified that Mrs. Jennings was a mentally ill person, severely mentally ill person, I think was the testimony, if I recall correctly, who had her own history of abuse and neglect and problems and was sexually abused. And Mrs. Jennings then left Mr. Jennings as a child in the care of some of these people that she knew to be child molesters. None of this came out at the penalty phase.
Was there concrete evidence presented at this evidentiary hearing that Mr. Jennings was abused? Or was that really other inferences that you draw from other people being abused?
When you're saying abuse, are you talking about sexual abuse?
Yes.
Okay, there's no direct evidence that Mr. Jennings was sexually abused, but there's other significance to the facts that were presented. The fact that the mother would neglect the child in such a way as to leave him in the care of people that she knew were child molesters or sexual predators, I think speaks volumes about the level of care and mothering there.
And she knew this based on what evidence?
Based on, well, she was victimized herself, but also based on the knowledge in the community that these people had been convicted and were in fact convicted of sexual offenses. So, to suggest that Mrs. Scudder's knowledge was limited because she only stayed with Ms. Jennings for a limited period of time, I don't think is a reasonable inference to draw from that. I think that Dr. Sultan's testimony was graphic. It was detailed. She met with Tawny Jennings on several occasions and got a history there, much above and beyond what trial counsel knew. The state wants to make an issue of the fact that Tawny Jennings didn't want to come and talk to the defense experts, and I submit that that's just that is unreasonable to expect that a mentally ill, physically ill mother of a defendant who's facing 3 life or 3 death penalty sentences would necessarily be that forthcoming. The duty then is on the attorney to have a qualified person go to the home of that person, not try to get on the phone and convince her to come and talk to the doctors. That's not the way it's supposed to work. That's not a reasonable investigation. With regard to the out-of-state witnesses, I think there's some confusion. The record, as I understand it, demonstrates that counsel wrote to Heather Johnson. I don't recall any testimony about counsel having contacted other people in Oregon or out west. The only person that I'm aware of is Heather Johnson. And counsel only knew of Heather Johnson through Mr. Jennings. Nobody did any other investigation of Mr. Jennings' childhood in Oregon. Heather Johnson wasn't in Maryland, to my recollection. She was the person with whom trial counsel had correspondence, and that consisted of 1 letter out and 1 letter back. I think it's also unreasonable to assume that Heather Johnson's testimony would be damaging because she said that she believed Mr. Jennings could commit a robbery and not a murder. Compared to what the penalty phase witnesses testified to on cross-examination, I don't see that as damaging at all. The witnesses that trial counsel chose over available witnesses like Heather Johnson testified that he would have the propensity for committing such a heinous crime as this. So any inference that can be drawn from Heather Johnson saying that she could see him committing a robbery, I don't think has any significance here at all. I mean, we're talking about a severe case, obviously, and the thought that a witness might say that he was capable of a robbery, I don't think should play into that analysis at all. I think it's clear here that there was not a reasonable investigation conducted, and prejudice resulted. I would ask the court to reverse the trial court's order and grant a new penalty phase.
Thank you for your arguments.
Thank you.
The next case for the day is Robards versus State of Florida.
May it please the Court, I'm Steve Bulletin from the Public Defender's Office in Bartow. I represent the appellant Richard Robards. This Court has a tool in the shed that it's made it clear that we'll only very sparingly use. If there was ever a case where the use of the ineffective assistance on the face of the record exception was appropriate, this is that case. Okay, the Eric Simmons case, decided about 3 weeks ago, pretty much capsulizes all of the principles of law discussed in my initial brief and my reply brief. And this Court said that where available information indicates the defendant could have significant mental health problems, such an evaluation is fundamental in defending against the death penalty. I would suggest that Simmons is pretty much dispositive of the deficient performance and the prejudice issues in this case.
Is your argument basically that the information that was presented at the Spencer hearing should have been presented to the jury?
Absolutely, yes.
In this 7 to 5, I guess, jury recommendation.
It was a 7 to 5 death recommendation.
Okay.
And the thing is that trial counsel knew, or at least he at the second Spencer hearing, he was having an attack of remorse, and he kept vacillating between remorse and self-preservation. But he made it very clear that he thought that this mental health evidence was compelling and that it could have affected the jury's recommendation, and he wished he had known what he had. But he didn't. But the problem is here that the question now is whether a reliable jury penalty trial in which Robards is represented by competent, loyal counsel acting as an advocate within the meaning of the adversary system, whether that's going to happen sooner or later.
But let me ask you this, because you just made a statement that that the defense attorney was vacillating between believing he should have used this information in a different way and self-preservation. And so my question then is there enough information in this record with this kind of vacillation that we should make an ineffective assistance of counsel determination on?
Absolutely so, because first of all, there's two things that you have here that you almost never have in an ineffectiveness claim. Number one, you know exactly what the testimony would have been because it was presented in the trifurcated Spencer hearing. So you've got the testimony of Dr. Wu on the PET scan, finding 3 separate areas of brain damage.
There's the PET scan.
You've got the testimony of the psychopharmacologist, Dr. Littman, about the effects of the 2 decades of anabolic steroid use and how that would exacerbate the brain damage. And you've got the testimony of Dr. Berlin finding that the 2 mental mitigators applied. Now, what's important, the other thing that you have in this case that you never have, the whole point of requiring 3.851 in the overwhelming majority of cases is to find out what the attorney's reasons were for doing or not doing what he did, for investigating or not investigating. In this case, we know that because Richard Watts put it on the record. And the judge and the prosecutor basically were trying to supply him with, well, wasn't this strategic? And Watts basically said, well, it was a potential strategy. I've done stuff like this in the past, cite maybe to the Harry Butler case. But
was there some question about needing more time to develop this mental health expert? Right.
I mean, I'll give you 2 quotes from Richard Watts. When I agreed to get on this case with Mr. Hoffman, we knew the case was over. And out of respect to the system, we agreed, and I agreed with Mr. Hoffman, to move forward as fast as we could. Second quote.
And he agreed with them to move forward as fast as they could because?
Out of respect to the system. I guess he was thinking the judge really didn't, wanted to move the case along, although the judge made it clear that he would work with the defense if necessary.
So the murder was committed in what year? And when was the murder actually committed?
The murder was committed, I believe it was in 2006, August 2006.
And when was the trial?
Trial was in 2010.
And that was moving pretty quickly?
But the sentencing was not until October 29.
The sentencing, right. The trial was in May. Then there were 3 Spencer hearings. And then the sentencing, was it in October? I think the 3rd Spencer hearing was in October. The sentencing may have been a month after that.
Now, the penalty phase, the date of the phase 1 was May 18th through the 21st.
That sounds right, yeah.
Right, and the penalty phase did not begin until May 25th. So there was about 4 days in between.
There may have been a weekend in there, yeah.
In between.
Right.
But I guess my thing, you're saying they wanted to move this pretty quickly. Were they new attorneys to the case?
Yeah.
And the case had started with some other attorneys?
I'll give you the. Let me read one more quote and I'll give you the background of how they came on the case. And I asked the court to consider, we knew when we came onto this case that we wouldn't be able to marshal the mental health materials in time to present to the jury. Now, the circumstances here is originally Robards was represented by the public defender. Robards was a difficult client because of his mental problems and because of his obsession with this sovereign citizen doctrine that he kept, filing, volumes and volumes and volumes of materials in the record. And the public defender moved to examine him for competency, and the initial ruling was that he was incompetent to stand trial. And he went to Chattahoochee for a period of time. Chattahoochee returned him saying they thought he was now competent. There was a second competency hearing. He was ruled competent. The public defender moved to withdraw based on conflict of interest because they represented numerous potential witnesses in the case, one of whom was Shane Harper, who proved to be a critical state witness. So the regional counsel was appointed. It was John Thor White and Steve Fisher. Robards had a conflict with John Thor White, and after a series of Nelson and Ferretti hearings, Robards was allowed to represent himself, which he did for a period of time of less than a year. He was wanting all along, to be represented by private counsel. Eventually his mother came up with $10,000 to hire a private attorney from Brooksville, Larry Hoffman. But at that point, Hoffman said, this is pretty much all the money that's going to be forthcoming. What do we do about penalty counsel? And what ultimately occurred is it was decided, John Thor White from regional counsel didn't want any part of this case at that point. He ended up moving to withdraw, and Richard Watts, a private attorney from St. Petersburg, was appointed. And then the question became, the JAC was contesting whether or not you could even have.
Okay, so all of this, so when did these attorneys actually start on the case?
Hoffman started on the case in February 2010. Watts, there was a period of time when there was a lot of debate as to whether or not he was going to even be appointed or whether or not he was going to be paid, and that rattled around for about a month. There was a series of hearings with the chief judge.
So ultimately there was only 3 or 4 months between the time of appointment and the time of the actual trial.
As a practical matter, I'd say there was 3 months for the guilt phase attorney and 2 months for the penalty phase attorney.
And so what, if anything, had been done in the interim before their appointment about the penalty phase?
You mean by other attorneys, you mean?
Yes.
Okay, the public defender had enlisted the services of Dr. Berlin. Dr. Berlin testified on the competency issue. So he had examined Robards, and he already had an opinion about Robards' paranoia and delusional belief system, and that he was pretty severely mentally ill. And he was one of the
experts that was presented at the Spencer hearing.
That's correct. Now, Dr. Berlin was of the opinion that he thought that it was very likely that Robards had organic brain damage. So Berlin recommended that Robards be tested for organic brain damage. It was not until April of 2010 that penalty phase counsel Watts even filed a motion to have the testing done, the PET scan done. By the time of
so now we have the PET scan. I assume because the PET scan was done that the trial judge granted the motion for the PET scan, and that was done when in relationship to the actual penalty phase.
All right, here's the sequence of events on that. The motion for the PET scan was done in April. The PET scan was done. The interpreting physician was Dr. Wu from California. He received the data from the PET scan in May. It's not clear exactly when in May, but apparently he reported back to. In the meantime, in April, Mr. Watts made the statement to the trial court in open court that he was becoming concerned about his ability to be prepared for the penalty phase.
Okay, but wait a minute. I missed when Dr. Wu actually interpreted the PET scan and sent that information.
The best I can give you is that he interpreted it in May, and that Watts had, as of 4 days, I believe it was, before trial, Watts was telling the trial judge, I'm not going to present any mental mitigation, we're waiving that, or I'm not going to present any to the jury. And at that point, he didn't have anything back on the PET scan, but he indicated that he might shortly. It appears that sometime before the penalty phase, which, as Justice Labarga pointed out, was a few days after the conclusion of the guilt phase. By that point, Watts had received some information that there were abnormalities. but he did not have the complete report because he stated at the second Spencer hearing that I had no idea how good or how profound the evidence of the PET scan was going to be. So basically what you've got is he did have, I guess, some telephonic knowledge from California that we've got some preliminary abnormalities. He didn't do anything with that information other than just go ahead and plow through this weak penalty phase that he did. And then he tried to play catch-up during the series of Spencer hearings. But he made it clear that he did not have the full knowledge of the PET scan.
Let me ask you this. I mean, it's a side issue, but it concerns me in many of these cases. This murder took place in August of 2006. The case did not go to trial until 2010, 4 years later. And what you just said and what I've read, seems like early on in the case, the public defender had it. He was sent to Chattahoochee because he was found to be incompetent to stand trial. Not exactly clear as to how long he was in Chattahoochee. He sent back to Bartow again, wherever, now competent to stand trial. And it was only then that the public defender discovered that they had a conflict. Did you not have a witness list before he was sent to Chattahoochee? See, that just threw the whole case in a tailspin as far as representation is concerned. Why did it take that long for the public defender's office to realize they had a conflict? The witness list was there, I'm sure, from day one.
Well, I can't, the public defender's office, this was the public defender's office in Pinellas County. It was not a Bartow County.
I'm sorry, Pinellas County.
Right. Now, why, I can't necessarily answer that. I don't know. I think that they would have known that Shane Harper was a witness in the case, but it's possible that they didn't represent Shane Harper until later. Although in that situation, logic might say, why did they withdraw from Shane Harper? Can't answer that. But I'm not sure that's really what threw it into a tailspin. I think what really, we're talking about a 4-year delay between the charged crime and the trial. That's a little bit long, but it's not tremendously unusual. And when you've got a defendant with the mental problems that this guy has, I don't think there's anything tremendously unusual about that. Now, what is a serious delay, for example, in the case you just heard, Brandy Jennings, the case there, the crime occurred in 1996. The post-conviction motions were filed in 2000 and were not heard until 2009. Here it is, 2012, and you're hearing the case on the initial appeal from the state post-conviction right now. That's been 16 years. If he loses here and it goes into federal court, how many decades is that thing going to be rattling around? Now, what we've got here is we have got an unreliable penalty phase where virtually nothing was done to advocate for this, for Richard Robards' life. And this is a penalty phase that the death penalty cannot constitutionally be carried out, and we've got enough information in this record to know that. Now the question is, do we want to do something about that now and maybe have the new penalty phase in the fall of 13 or January, February of 14, or do we want it to be in 2027, like in accordance with how the Jennings case went? At some point, sometimes defense attorneys get accused of delay. I'm not sure I think that's fair, but in this case, we're arguing against delay. We're saying the whole point of the ineffective assistance on the face of the record exception is that sometimes it's in the interest of justice and also in the interest of conservation of time and resources.
Just from your experience, what is the doubt? There seems to be an element of strategic decisions here in waiting to present this evidence to a Spencer hearing as opposed to present to a jury. But what would be the downside? I'm trying to think of this. I put myself in the shoes of these lawyers. What is this downside of everything you got to the jury, and the judge's going to hear it anyway, and as opposed to just saving it all for the judge and not let the jury hear it? I don't understand that.
I don't understand it either, and that's a very good point. I mean, I've been to, the judge made some kind of comment about, well, they tell you at life over death conferences to save something for the judge. Well, first of all, they don't tell you to save everything for the judge. But second of all, I've been to about 20 life over death conferences, and it would be grotesquely ineffective advice to tell an attorney, particularly in Florida now, where there's basically no such thing as an override. It's been 18 years since the life override was affirmed. It's been 20 years. The Coleman and Robinson cases were 20 years old, and they just got relief. Okay, there basically are no life overrides in Florida anymore. So if you get a life recommendation, you're going to get a life sentence, particularly if there's mental mitigation. If you get a death recommendation, you got a lot to overcome. The judge it's legally required to put great weight on the jury's recommendation, and they do. So what would be the downside would be, okay, let's say you got a situation like Wong versus Belmontes, which is cited in my reply brief. Let's say you got a case where you know what the mental mitigation is, and maybe you think it's pretty good, but you also know that it's going to open a huge can of worms. Like in Wong versus Belmontes, a prior murder is going to come in. So you make a strategic decision, okay, I'm going to tailor my mitigation so that the jury will hear that which is not going to open the door to stuff that's going to be way worse. Now, that's not what went on in this case, because first of all, you can't make that strategic decision until you know what you got. And I'd cite the Luther Douglas case out of this court for that. Here, Watts made it clear he didn't know what he had. He said, I couldn't make the complete decision, and the judge said, that's right, you couldn't, but you might have, would have made the same decision.
Are you saying it was not reasonable?
Absolutely not reasonable. There were reasonable strategic determination has to be made after a reasonable investigation. That means a timely investigation. Watts had an obligation to request a continuance if he didn't have time to do his mitigation investigation, and particularly here when the judge pretty much telegraphed that he granted.
I'd assume this record demonstrates that he never asked for a continuance.
Hoffman asked for a brief continuance in March until May. But at the point in time when Watts realized that he wasn't going to be able to marshal his mental mitigation, he never asked for an additional continuance, even though the judge basically said, here's a quote from the trial judge, if I can find this here. If we're careful on the front end, it can save a whole lot of anxiety and time on the back end. The trial judge made it clear that he would be willing, maybe reluctantly, but he would be willing to grant a gap between the guilt phase and the penalty phase if that was necessary. And we know that can be done. In the Blackwood case, there was, I believe it was a 7-week gap. Or they could have...
Was there anything other than the Dr. Wu's information that was not available beforehand to the defense attorney?
Dr. Lippman's information, which was critical, was even more so because there was Watson.
When did defense attorney get that information?
After the penalty phase. He didn't even move to have the neuropharmacologist appointed until after the penalty phase. Then Lippman came down and interviewed Robards and tested him for a period of an entire day. And he gave testimony at the Spencer hearing about Robards' 2 decades of anabolic steroid abuse and how that would aggravate his pre-existing brain damage. So that basically what you have is 3 different areas of strong mental mitigation that kind of overlapped and dovetailed. You got the 3 areas of brain damage, some of it traumatic, some of it toxic, corroborated by his steroid use and by his series of accidents. You've got the steroid use itself, which can make you paranoid and delusional, and then you've got the testimony of Berlin kind of wrapping it all up and supporting the 2 mental mitigators. I want to get in a second to the state's point about the girlfriends, but in response again to Judge Labarga's question, another thing that the court has to realize is even if there was some concern about, well, maybe I'm going to open the door to some bad rebuttal, the rebuttal in this case wouldn't have been that bad. It was really pretty weak, as detailed in my reply brief. But even the brain damage testimony, the testimony about the PET scan and the 3 areas of brain damage could have come in without opening the door to anything, and that, in fact, is the very strategic decision that this court approved that the trial attorney made in the Sexton case. In the Sexton case, they didn't want to put on the testimony, I believe it was of Dr. Mayer, about his possible mental problems because it would have opened the door to Mayer's opinion that Sexton was a sexual sadist, which would have obviously been devastating to the jury. So what Sexton's attorney did is he limited his mental mitigation to the PET scan, to the evidence of brain damage, which this court recognized in the Crook case and in various other cases that organic brain damage can be a very compelling mitigator. Now, that could have been... now, let's say that Watson...
Was there any other evidence other than the PET scan of the organic brain damage? Did we have any other testing to establish The organic brain damage other than the PET scan?
Directly, I don't believe so. There's corroboration in the form of testimony from the girlfriends that he did. There's evidence of a series of accidents, either some car accidents, way earlier, and then a motorcycle accident.
I'm talking about neuropsychological testing is one of the established ways
Yeah,
to establish that we don't have that.
you talk about like Dr. McCraney sometimes gives. I don't believe there was anything like that in this record. But there was corroboration of both his anabolic steroid use and his series of accidents. There was also behavioral corroboration from the girlfriends Faye and Tara, who testified that his delusions and his paranoid behavior increased after the motorcycle accident with one was with a car and one was with a dumpster after those occurred. Now, that's another thing I want to talk. The state makes a big point about, well, they're saying no prejudice here because of this rebuttal that would have come in. Well, number one, Watts didn't make that strategic decision, and I'll cite the Douglas case for that. But number two, he could have introduced the PET scan and the organic brain damage without opening the door to anything. Number three, what's the main thing they talk about as being this devastating rebuttal that would have come in? The girlfriends. That wouldn't have been all that bad, and in fact, it might have been pretty good to establishing the statutory mental mitigators, because Dr. Berlin testified that he talked to 2 family members and 5 ex-girlfriends, and he thought the ex-girlfriends were extremely important because they don't like Richard Robards, and they weren't motivated to help him. And he thought that was more, family members are inclined to try to help. Co-workers don't really see, have an intimate enough relationship with you to necessarily see this stuff, but the girlfriends would. They all testified that their testimony and Dr. Berlin's opinion corroborated that yes, he's delusional, yes, he's paranoid, yes, he appears to have auditory hallucinations. One of the girlfriends testified that he would board up he would become convinced that people were trying to shoot him, and he would board up the room that he was in, and that there was absolutely no basis in reality for any of this.
Going back to Justice Lewis's question as to what other evidence of brain damage, there was also the MMPI, which confirmed psychosis, although it can't prove brain damage, but psychosis is caused, according to the experts, by brain damage in this case. So that was another incident.
And I think that what's interesting about that is that Berlin gave the MMPI. And the MMPI, among many other things, caused Berlin to conclude that the mental mitigators did apply, that he was psychotic, delusional, paranoid, and it caused him to believe that there was a likelihood of brain damage. That's what triggered his recommendation. We should get this guy tested for brain damage. They gave him the PET scan. The PET scan confirmed 3 separate areas of brain damage, which then gave corroboration to Berlin's opinion that, yes,
were the experts arguing for the two statutory mental health mitigators?
The only expert who was asked about that was Berlin, and he said that they both applied. He said that the extreme emotional and mental disturbance applied, and as for the impaired capacity, I believe what he said was that he had impaired capacity to conform his conduct. And
how did the trial judge then evaluate that information?
The trial judge did not find the mental mitigators, but he found Robards' mental problems as a non-statutory mitigator and accorded it some weight. That, of course, though, doesn't mean that the jury would have evaluated it the same way, particularly in a case where the jury's recommendation was 7-5. And that, again, is one of the strongest arguments on the prejudice prong. It's not this court has found that there's prejudice even in cases where the penalty recommendation was 12-0. The Simmons case is like that. The Hildwin case is like that. But in cases where the penalty recommendation is close, and I'd cite Phillips, Rose, and the Outen federal case out of Delaware, which also allows non-unanimous jury recommendations, that the fact that it would have taken a swing of only a single vote to have changed the outcome causes the undermining of confidence in the result. Now, here you got a case where 5 jurors felt that life imprisonment was the appropriate sentence, even though they really heard only a skeleton case in mitigation. Now, why that does not disprove ineffective assistance of counsel. I mean, in the Coleman and Robinson cases, trial lawyers actually were found ineffective even though they had gotten life recommendations. Why would the jury have recommended, why would 5 jurors have voted for life in Robards' case? Possibly because they found that the murder wasn't planned. They may have disagreed with, they may have not found the hack aggravator because trial counsel argued pretty strongly against the hack aggravator. But all it would have taken is one additional juror.
You talk about, in this case, the hack aggravator was severely challenged?
Yes. It was challenged. I mean, I didn't challenge it on appeal as a matter of with this. Kind of mental mitigation. So, you know, I really don't know what to say other than the fact that there's no reason to send this case back for more proceedings that could take years or decades to get Robards' penalty phase that he's going to have to get at some point anyway because this penalty phase was just not reliable. If I don't know if I have any time left or not.
Yes, you have a little over 3 minutes.
Okay, well, I'm probably using up my rebuttal time, but I do want to point out another thing that you know, I'm listening to the stuff that was being talked about in the prior argument about childhood and not knowing anything about a guy's life before he was 13 and having a chaotic upbringing. Well, the part I'm going to talk about now, I think there's plenty here that reversal for a new penalty phase should happen sooner rather than later. But there's one thing here that we have no idea why Watts did or didn't do, but it's really pretty amazing, is that in the penalty phase there was very, very superficial testimony about Robards being a nice guy, and he had a preschool teacher, and his grandfather said he was a happy-go-lucky kid, and they presented, I think, the Kentucky videotape was at the penalty phase. The folder, I think, was in the Spencer hearing, but there were, like, pictures with puppies and things like that, and it created a wholly misleading, benign conception of his upbringing that allowed the prosecutor to argue to the jury, hey, this guy had a fine childhood. He was not abused. He had brothers and sisters and animals. And how was that mitigating? How was that mitigating? Well, at the third Spencer hearing, finally, the sister, Tanya Robards, was called to testify. And it turns out that Robards had anything but a fine childhood. He was seriously abused by his stepbrothers to the point where his sister didn't understand how it is that he got through that childhood without hanging himself. The abuse that she didn't directly experience. Just living at that house made her suicidal for a period of time and depressed. And she felt like somebody should have saved Robards. And what saved Robards eventually? She said he didn't get out of it until he joined the football team, which happened to be when he started taking the steroids, and it was nobody was going to beat on Todd anymore. He was going to become Damien, the bodybuilder, and that led to the 2 decades of steroid abuse, and that contributed heavily to the brain damage. And the jury heard none of this. The jury heard nothing essentially, and you can't execute somebody based on a penalty phase like that, and it needs to be taken care of sooner rather than later. Thank you.
May it please the court. My name is Stephen Acom. I'm Assistant Attorney General on behalf of the state of Florida in this case. This court has noted on numerous occasions that a claim of ineffective assistance of counsel may be raised on a direct appeal, but it's only in the rare case when both prongs of the Strickland analysis are found and apparent on the face of the record. This is not one of those cases. We clearly do not have a showing on the face of this record that trial counsel was deficient or that Robards was prejudiced by it.
Can I ask a question? This almost appears, right on the edge of a setup. But I'm a defense counsel. I've got some stuff. Let me roll the bones. But it's very clear that I've not used anything that's in my arsenal. I'm going to hit it later.
Well, Your Honor, I think.
Then what's the state? Just going to go on another 20 years? We've heard. I think I've been doing this now 13 years, 14 years, hearing the arguments, and I don't believe I've ever heard one where a lawyer just takes off and goes to trial on something, and he's got information in his hand just for convenience.
Your Honor, I've dealt with Mr. Watts on previous cases where he's taken this same exact approach, where
it's a setup.
Where he goes with the good defendant theory in front of the jury and withholds the mental mitigation. And as the trial judge pointed out, it's something they teach at the seminars, that's a good way to go back to the trial judge and say, hey, look, in this case, I got 7-5 recommendations, and now I have all this other stuff I want to present to you, Your Honor, because the theory is that I guess it's better presented to a judge rather than the jury. And in this case, it's probably correct because of all the negative information that would have come out had they tried to present that to the jury. But he had the information. The counsel argues that he failed to develop it and didn't know it and couldn't have made that strategic decision, but that's inaccurate. And what we do know on the record is at the time of the penalty phase, Mr. Watts had obtained the PET scan results already. We don't know the details. We know it's a preliminary report is what his statement is to another judge. This is a unique case because I've never seen so many transcripts where we have the fee hearings. So we have a lot of statements coming from Mr. Watts where he's in front of another judge with the JAC attorney present discussing what he's doing and why he's doing it and how much money he needs and so forth like that. But we do know that he had, prior to the penalty phase jury, he had the PET scan results. He also was aware, he's working with Dr. Berlin.
You say he had this information prior to the penalty phase. When you say the penalty phase, you mean before you went before the jury?
Correct, Your Honor. The trial dates, I believe, were the 17th through the 20th of May, I believe was or through the 21st, I believe, of May, which was a Friday. And during the trial, the judge had indicated to Mr. Watts, do you want to start the penalty phase on Saturday or on Tuesday? And Mr. Watts said on Saturday. He was ready to go right away, and then they ended up moving it to Tuesday. So the trial ends on a Friday, and the penalty phase starts the following Tuesday.
But how does that demonstrate that we know he had the information?
Well, we know from 2 days later, he goes in front of the chief judge on one of these fee hearings and says, I had the results. I had preliminary results that showed abnormalities. So we know he knew about it at the time based on his statements later that he had these results. We know he had done a motion to get the PET scan. Robards had been transported on May 7th, I believe, was the date that he went out there, and I believe
let's stop right there. I believe he said that it was in April that he actually filed the motion to have the PET scan, correct?
I won't disagree with that.
Okay.
He came onto the case in late January 28th was when he was appointed, and he immediately filed motions to obtain a mental mitigation specialist and also a mental health expert, Dr. Berlin.
So when did he know, prior to the April motion, of a necessity to have a PET scan?
We don't know, Your Honor. This is a classic reason why we need to do this in post-conviction, because we need to kind of develop all these facts. Is basically, we know that counsel had obtained all the information from the prior attorneys, including the competency stuff, and that's where Dr. Berlin, who's Dr. Watts' expert, testified.
You said including the competency information.
Right.
Was there any other mitigation information that had been developed at that point?
We really don't know beyond what's in the record, Your Honor. What's on the face of the record. We know that there are two confidential defense experts testified at the competency hearing, Dr. Mayer and Dr. Berlin. Those had been retained by the Public Defender's Office at the outset of the representation, I guess. Those two doctors had information. They had examined him, and they were saying that he was incompetent to proceed. They sent him to Chattahoochee for a year, I think it was. He tried to escape from there, and then they brought him back, and they had the doctors from the state hospital testify in addition to Dr. Berlin at another competency hearing where he was then found competent. And I would point out that is where all this, the reason why Dick Watts would take the position of I'm not going to introduce mental mitigation is because of the stuff that came out at the competency hearing. If you hear the state's experts and read their reports, you'd see all the negative information that would come out if he had gone that route in front of the jury. Namely, that he was malingering and he had no mental illness. He had an antisocial personality disorder was all that the state experts found with this guy. He had done this escape attempt and had created a dummy and had talked two Chattahoochee employees into giving him a saw so he could saw out his window and try to escape. He was wearing multiple sets of clothes and had taken tuna with him and so forth like that. They also had an abundance of information about him malingering his alleged mental illnesses, and that included not just the competency stuff, but his behavior in court, all leading up to trial. He had been, when he was representing himself in pro se, and all throughout this, he was doing very crazy things, trying to basically stall the system. He would sit in court and sing Amazing Grace, and they had to eventually remove him from the courtroom. But that's the kind of stuff
that be taken two ways? I mean, as opposed to trying to delay the proceedings, I mean, that could have been a real indicia of some kind of mental illness.
Well, not when he admits later that that's what he was doing, type of thing. Is that he comes in and basically, if you read the trial judge's sentencing order, you'll get a flavor for why the trial court rejected some of this information, because of a lot of it was based on Robards' self-reporting, and he basically has been lying and malingering throughout this whole period. He told the trial judge, for instance, the second Spencer hearing, he says he won't take responsibility for the murders or anything of that nature, but then at the third one, a month later, he's saying that he did it, but he can't remember any of the details of it. And he also says that his escape attempt while he was at Chattahoochee was so he could go look at the stars. That kind of stuff. He's not being truthful even at the late game of the third Spencer hearing, when he's allegedly showing remorse for these murders and taking responsibility for them. That's the kind of stuff that, had they presented the mental mitigation, would have come out in the state's case in front of the jury. So I think the attorney is making a strategic decision. Let me go with this good guy theory in front of the jury, which resulted in a 7-5 vote in this very heinous murder, and then turn around and, a month or two later at the Spencer hearing, tell the judge, oh, look, I want you to override, and sentence him to life because we think this mental mitigation would have tipped the scales. It's a strategy that this attorney has used in the past and is using again in this case. And he said, on the record, he says it was a strategic decision as to doing that. So,
well, did he vacillate on that statement at all?
Well, he certainly gave indications that, wow, I wish I would have known how great all this evidence was that I developed. And again, though,
well, what disturbs me about is a statement like that sounds to me like he really had not had an opportunity and had not evaluated that information prior to whatever decision he made not to put it on before the jury.
I think it's more a reflection of, look, I got a 7-5 vote, and boy, if I would have known what I know, have developed. The key, though, is he knew it at the time of the penalty phase. He may have gotten further information, but he knew the basis of all this. He knew the PET scan, and they talk about, well, he didn't get the neuropharmacologist until well after the penalty phase. Problem with that, and that's accurate, he did not move to have Dr. Lipman appointed until after the penalty phase. However, Dr. Berlin had testified at the competency hearing and was working with Mr. Watts on the whole theory of steroid use and its effect on his brain damage. So counsel knew about it. He just didn't. He was trying to get an expert, and he's working with Dr. Berlin to get this expert.
Well, so your position is that Berlin, through the competency process, was also of the view that there was brain damage?
He testified that Robards had abused steroids. Was his
I understand.
indication.
That's different. That's a different story. The question is whether there's brain damage.
Well, his position was that would have affected it if he had brain damage. The steroid use, that there was apparently research.
Well, this develops later. My question is during the competency time frame.
Right.
And you said Berlin was appointed for that?
Yes.
And was Berlin of the view that there was brain damage? Is that in the record?
I don't know if that's in the record at that time.
Okay. All right. That's fine. That's a simple question.
He certainly indicated that there's evidence that steroid use would basically affect any kind of brain damage that he may have. But again, Mr. Watts was aware of that, and he was working with Berlin to try to come up with an expert that could come in and testify just as to that specific point. But again,
so I mean, if he was working with other people to try to get some more information, wouldn't it have been, wouldn't a reasonable attorney have said, Judge, at this point, I am still trying to develop this mental health mitigation. So can we have a continuance for a month or whatever in order to fully develop what it is you're trying to do?
Well, he was given that opportunity and he didn't want to take it. He stated on the record, I'm not going to present mental mitigation. That was his strategic decision. And the problem with this is we don't know why he made that decision. And all, I mean, we certainly have a glimpse of it based on statements he made, but we don't know what he said to his client or what his client said to him because of the attorney-client privilege that won't be waived until subsequently in a post-conviction proceeding. But it's very likely that Robards was dictating what he wanted to be done because prior to Mr. Watts ever even coming onto this case, when Robards was pro se and had standby counsel, John Thor White, there was a colloquy between them that the judge was explaining mitigation, and Mr. White said, we have a very different take on what would be presented to a jury. And obviously Mr. Robards had a view as to what he would present, and it may or may not have been a factor in Mr. Watts's ultimate decision. We simply don't know. That's not on the face of the record, and that's something that one of the main reasons why we need to raise this in the appropriate time and form, which would be in a post-conviction motion, where we could hear what the client was telling the attorney as to what kind of presentation he wanted. But this court has said you have to be able to note deficient performance and prejudice on the face of the record, and that's not done. Very clear with the deficient performance. It's also clear with the prejudice. Your Honor asked opposing counsel about what would the prejudice be. Why not throw everything at it? And I talked briefly about it, but there is a wealth of negative information had you gone that route in front of the jury. Counsel talked about the Sexton case, and I would point out that in the Sexton case, the case he was talking about was actually based on the second resentencing. In Sexton, the very first resentencing was a 7-5 vote with no mental mitigation. At the second one that counsel is citing that opinion for, when they introduced the PET scan, it was an 8-4 decision. So just the fact that you want to present mental mitigation may not, in fact, affect the jury's recommendation in this case, and it would have opened the door for a lot of negative information to come forth.
And the fact of the matter is we don't really know what all that would necessarily be. There's not been an evidentiary hearing when the states had the opportunity to present evidence. I mean, so we're, to a large extent here, we're kind of operating in a vacuum, and it requires speculation about what the whole context might be like.
Exactly, Your Honor. And that, again, that's why it needs to be, denied now, but without prejudice that he can raise it in a post-conviction motion. And unless this court has any further questions, I would just ask this court to affirm his judgments and sentence. Thank you.
Thank you. I have 1 minute for rebuttal.
In the past, my strategy has been, in the very recent past, to save mental health and take a high road approach. So yes, I'm addressing that for the record. Still in all, when it came down to the day, I wished I had the full scope of it. Still, I want to appeal to the court to consider how the jurors may have taken this. I had no idea how good it would be, the PET scan.
Mr. Bolton, the one thing, since I've known you to appear here, you've always been candid with the court. You're one of the finest lawyers that I've seen argue here.
I appreciate that.
What concerns me here, how in the world do we stop game playing in these proceedings if we agree with you? I mean, let me tell you what my mental impression's coming out. I've got a lawyer, maybe he's a very good lawyer, maybe he's a very crafty lawyer, and I've got some stuff, and let me take a run at this, and I've got nothing to lose. I'll take a run at it this way, and if that doesn't work, then I can follow up, and that concerns me. I mean, this whole system's going to fall apart. If I'm saying, well, give me a couple of bites at this apple.
Well, I think
help me deal with it.
As an officer of the court, the best way I could answer that would be that I think, if anything, that opposing counsel referred to. He said Dick Watts has done this before. Well, his track record is important, and in light of that, I'd ask the court to look at the Harry Butler case that came out less than a year ago. I don't have time to really get into the details of Butler, but the thing is he had plenty of incentive not to do what I think something has to be done like now to prevent this kind of penalty phase from occurring. Now, at the point in time, Mr. Hoffman got paid $10,000 by the defendant's mother to do the guilt phase. Mr. Watts asked for eventually $62,000 in change, 4 times what the JAC rate would be, because of the extraordinary work he put in on the case. Well, yeah, maybe he did put in some pretty good work, but he did it after the horses were already long out of the barn. There was already a death recommendation to overcome. Now, he had, at the point in time when what was going on with the the mea culpa, is I wish I had this. This really could have affected the jury. This was compelling mitigation. But, yeah, I might have made the same strategy anyway. He had a real incentive for the court not to say. What the court should have done at that point is said, we got a problem here. You should have told me about this back in April, back in May. Now, what I got to do, you're off the case. I'm not going to sentence him. I'm going to order a new penalty phase with competent, loyal counsel who is going to investigate the mitigating circumstances and make a reasoned strategic decision what to present and what not to present. I think we need to do something now to make sure that we don't keep getting penalty phases like this, and that's the best way to answer your question. I don't really have time to get into what the state said about the rebuttal, but my reply brief addresses that in great detail.
Thank you for your arguments. The court will be in recess for 10 minutes.
All rise. All rise. Supreme Court of Florida is now in session. Please be seated.
The last case for the day is Matarranz versus State of Florida.
Good morning. May it please the court. My name is Robert Coulter, Assistant Public Defender, appearing on behalf of the petitioner. The issue this court must resolve in this appeal is what is an appellate court's role in determining whether there is sufficient evidence in a record to support a trial judge's conclusion that a juror can be a fair and impartial juror. The Third District Court of Appeals in this case concluded that as long as there is anything in the record to support the trial judge's determination that a juror can be fair and impartial, the appellate court must accept this determination. In reaching this conclusion, the Third District relied upon partial case language from this court's case in Busby v. State, which recognizes that a trial judge is, in fact, in a better position to determine whether a juror can be fair and impartial. I believe where the Third District Court of Appeals decision goes awry in this case is how does this court or an appellate court to determine when the court looks at all of the responses given by a juror, not just isolated responses, but all of the responses, is there a reasonable doubt about that juror's ability to be fair and impartial?
Well, is there not? I consider this one of the most important cases to come before the court in a number of years because this is one that touches upon the validity of our entire system. And I hope you both understand the importance, in my mind, that somehow we and other appellate courts have allowed this to sort of diffuse. And I've noted for a long, long time, even before I came to this court, you can find an appellate decision to support your view in this area, just basically on the same facts going different ways. So I see this as really the need for a standard, both from the state's perspective and from a defendant's, to validate our system, because if we don't begin with a valid jury, then the question is not whether they got it right. The question is, do we ever have a valid panel? And so I'd like you to articulate for me the standard that one ought to use to evaluate what's going on. And let me throw into the mix just a little bit on, I mean, there's one kind of question. What do you think about the death penalty? I mean, that's sort of an open-ended question. Not many people know about it. On the other side is a response, my child was murdered. I don't think I can be fair. And it seems to me that those are two situations. You respond, I don't like the death penalty, or I do, where you're setting forth some pretty strong opinions, yet one may be more susceptible to discussion than the other. But what is the standard? We seem to have been unable to articulate a very good standard for all trial judges, and Justice Labarga, I'm sure, has encountered this. Both of you, if you've tried cases, you've encountered it. Every transcript you look at, you encounter this kind of thing. But what's the clarity of standard so that we just don't confuse it more?
I think that gets answered in several ways. And I think this court, as far back as Singer v. State, made it very clear what the standard was. But I think we start off with the premise that I think Your Honor has recognized, which is we start off with the premise that we're entitled to a juror that's fair and impartial. And as we go down that standard, we start questioning jurors, like the trial judge did in this case. This is a fascinating case to clarify the standard, because this case establishes so clearly what has gone wrong in the Third District Court of Appeals. The trial judge in the beginning of the voir dire in this case tells the jury, we want to know up front, are there any jurors that have a bias? There's nothing wrong with the bias, but we need to know that. And then the judge goes on to explain that one of the ways we know there's a bias is there something about the charges in this case that would prevent you from being a fair and impartial juror. The judge then goes to the entire panel, is the fact that the defendant was charged with a burglary in this case, does that prevent you from being a fair and impartial juror? Juror Sabala says, yes, I cannot be fair and impartial. So where do we go from this? This court has held in Singer v. State, if there is a reasonable doubt about a juror's ability to be fair and impartial, that juror must be excused for cause.
Then you get into the question I usually encounter on the trial bench. Have a right to rehabilitate that juror.
Correct.
So where do we allow that? In the instance, and the one instance I had on selecting a jury in a first-degree murder case where woman was strangled. And when the panel was brought into the courtroom, as soon as I told the jury what the charge was, this one gentleman in the back raised his hand, "Can I see you?" He comes up to the bench and he tells me 15, 20 years ago, in upstate New York, when I lived out there, my 17-year-old daughter was kidnapped, raped, strangled, murdered. Judge, and he's shaking, he's crying at the bench. Please, I don't want it. I mean, the fact that I'm here now is bothering me. Of course, defense counsel wanted him excused. And I sent him back, and then the prosecutor says, "Judge, I have a right to attempt to rehabilitate that witness." I mean, in that kind of instance, where you have this actual personal experience, should a judge just say, "No, this is enough, reasonable doubt, no rehabilitation involved," and it's over, he's excused? As opposed to some general experience where typical defense lawyer, not typical, but many defense lawyers, they get up and the first question out of their mouth, "Mrs. So-and-so, are you going to require my client to testify and explain what happened in this case before you can vote to find him not guilty?" Without explaining anything else, everybody says yes. See, in that type of situation, that general concept type thing, the prosecutor or the judge or whoever needs to come back up and perhaps attempt to explain to the juror. But you see the difference between two. Should there not be a situation where a judge can just say, "No rehabilitation, this is enough, I'm not going to put this guy through his questioning, he's gone"?
It would be our contention that there are two lines of cases, and I think this court's questions have recognized those two lines of cases. When a juror comes up and says, "I can't be fair," or as this juror says, "I will lean towards the state," or as this juror said, "I know myself, I can't give the defendant a fair trial," what is the purpose of rehabilitation? This juror hasn't made a mistake, like the prosecutor tried to instruct the juror in this case. At a certain point during this attempted rehabilitation, the prosecutor goes to the jury, Miss Sabellas, "You're not allowed to lean." Well, it is our position, yes, she was allowed to lean. She wasn't allowed to be on this jury, but she was candidly telling everybody in this courtroom, "You have the wrong juror for this case. I was the victim of a burglary when I was 8 years old. My Christmas presents were stolen. I am begging you. I cannot sit on this jury."
Again, I understand that. How would you describe the two different lines that you're seeing? How would you all describe that so this is a workable system that can be followed, that is understandable? How would you describe those?
I would describe it, there's one situation like this court recognized in Johnson, where when a juror comes in, I believe that it's a legal question. I believe that the death penalty gets applied in all cases. The trial judge, no, it doesn't. There are mitigating, aggravating circumstances. Questions where jurors are confused about the law, they can be rehabilitated. When a juror thinks that the burden of proof in a criminal case is the same as the burden of proof in a civil case, I would expect that a juror produce evidence in a case. And a judge goes, "Hold on, that's not the law." And a juror says, "Okay, if that's not the law, I can accept that. I thought defendants had to testify in a case. I never knew the defendant didn't have to testify in a case." A judge tells to a juror, a defendant doesn't have to testify in a case. The court then is in a position to say, "You know what, I believe the juror. The juror said they can follow the law." It is our contention, like in Judge Labarga's case, when a juror comes in and tells you, based on something that's happened to me in the past, I cannot be a fair and impartial juror, there is no rehabilitation. And coming to court today, I was thinking of when should the line be drawn? At what point in this case was the rehabilitation useless? I would say originally when the judge said to the jury, "Do you think it could be, who would be unfair in this case?" The juror raised their hand. I would say the judge had the right to ask one or two more questions, which is what happened in this case. The judge then went to the juror. "You said you couldn't be fair. Explain to me what happened." The juror says, "I was the victim of a burglary. It was Christmas time. and I'm going to hold a grudge against the defendant. The juror then said, I don't think I could be fair towards this defendant. The judge, in my opinion, probably should have stopped right there. There could be no more rehabilitation. But the judge went one step further, and he said, all right, I understand you may hold a grudge, but do you understand that you shouldn't hold a grudge against people who are innocent? The juror said, I understand that, but I can't guarantee you that I won't hold a prejudice towards the defendant. And she indicated, right pointing to the defendant, or indicating to the defendant, my prejudice would be against him.
Let me fast forward you to the peremptory challenge exchange there. There was a list of jurors that the defense said should have been stricken for a cause, but were not. This particular juror was not on that list, right?
Correct.
So did that list have to be given to the judge?
No. What the state's taken a position, I believe, that somehow we've waived this. And what this court needs to look at is Trotter v. State, which clearly sets out the entire procedure.
Well, my concern is this: if the list did not have to be given in the first place, right?
Correct.
So, but yeah, the list was given.
And should we be bound by if we give a wrong list?
So the whole idea behind this process is to be able to give the court notice, an opportunity to correct any particular problems that may exist, and to straighten the thing out, so we're not here later in an appellate court trying to redo the whole thing, right?
Correct.
So was it a problem by giving a list that wasn't required with this juror not on there? Did it somehow indicate to the trial judge that, well, okay, whatever problem that may have existed, they must be okay with now. I don't have that as an issue to deal with in this particular trial. It's somewhat of a unique set of circumstances, it seems to me, in this case, because of the defense giving them a list that wasn't required.
I don't think the failure to give a correct list waives anything. If we look at the procedure that's laid out in Trotter, there are basically two requirements in Trotter. One is preservation. You move to challenge your juror for cause, you give the judge the reason, which is exactly what happens, and at the end you renew your objection. That's the preservation part of Trotter. The second part of Trotter is that you have to establish prejudice, which is where the problem took place in this plot. The second part of Trotter is you're finished with jury selection. You need now to establish that you've exhausted all your peremptory challenges. You need another peremptory challenge, and there's an objectionable juror on the jury. At this stage, defense counsel informed the court he exhausted all his peremptory challenges. He asked for additional peremptory challenges. The judge immediately said, no, I'm not giving you additional peremptory challenges. Defense counsel identified a juror he would strike. It is our position that when defense counsel failed to include one of the jurors for a challenge for cause, it was harmless. It had no effect on anything. This wasn't the part at the time of the procedure where the trial judge reviews the challenges for cause.
Well, you indicated a harmless. So why is it this harmless error here? This particular juror did not serve on the jury, and by the defense actions of not naming this particular juror, it would seem to indicate to the trial judge nothing to be done here. So even accepting that this particular juror perhaps should have been stricken because a peremptory strike was used, did not serve, why is this not harmless error under the fairly unique circumstances of this case?
Because I think that you have to keep in mind that right before we were listening all of the purpose of an objection in terms of harmless and waiver was the trial judge put on notice of what our objection was. There was a lengthy argument right before this about this juror should not be on this jury. No, I don't think there's any way to look at this record to say that we are giving up our argument as to juror bias. This court has never required that you relist the jurors. Matter of fact, at the end of jury selection, when this becomes relevant or you have to renew your objection, the law doesn't require that you relist all the jurors.
No, I understand that.
And there would be no reason to list all the jurors. So to say that because defense counsel made a mistake and failed to include a juror that he at length had argued about that should have been stricken for cause, that somehow he waived it.
Let me ask you this, counsel. I mean, defense counsel did ask the trial court for additional peremptories?
Correct.
And that was denied.
Denied.
Right. So, your argument, I would think, would be that he exercised a peremptory challenge he didn't want to exercise, perhaps, and maybe kept this woman on the panel as a lesser evil than someone else that he wanted to exercise. In other words, what I'm saying is has she been excused for cause? As you were contending?
I would have had an extra peremptory.
You would have had a peremptory challenge to excuse someone else that he wanted to excuse as well. Is that what you're saying?
Correct. And at this point of the
that's
procedure,
the prejudice you're talking about.
Where we listed all the jurors, the only thing relevant at this point of the procedure is to put the court on notice that we need extra peremptory challenges and they're objectionable jurors. That was exactly done.
You have to point out those objectionable jurors.
Excuse me?
And
you have to point out.
Use a peremptory challenge, and now there's still. It should have been a challenge for cause. That's your argument, that this lady should have been stricken for cause. You use the peremptory challenge on her, and now you have a juror who is still objectionable to you, and you have no more peremptory challenges. Don't you have to point out the jurors that are still objectionable?
Yes, which was done here.
Oh, okay.
We identified all those. The issue here is that when we renamed the jurors for challenge for cause, we left the juror out. We pointed to all the objectionable jurors.
Okay.
Well, you left the juror out because you're no longer there.
No, I think we left the juror out candidly because the lawyer made a mistake. He relisted all the challenges for cause. He made a mistake. There's no other way to get around that. He needed to list 6 jurors. He listed 5. It's our position that it's irrelevant to what happened there. More importantly, I think this case does create a very, very important case because what the Third District Court of Appeals has done in this case and is doing in subsequent cases, which is cited by the state, is the Third District Court of Appeals picks out an isolated comment by a juror. Eventually, this juror said that she could be fair. How did she say she could be fair? According to the trial judge, the juror, according to the judge, concluded that this juror was embarrassed by her responses the previous day. And I would say that the juror was embarrassed about what? The juror had come into court and told this jury and lawyers from the beginning, I don't think I could be a fair and impartial juror. Over and over and over again, 6 times. I cannot be a fair and impartial juror. And I would say to the court, if the court's looking for a bright line test, it's when a juror says something from their heart, not something from their brain where they don't understand the law. When a jury comes in and basically begs a court, this is the wrong case. When I was 8 years old at Christmas, I was burglarized. If I was the defendant, I would not want me to be on this jury. Think what the juror said. The juror said, knowing me, I would lean towards the state. And what this court has always recognized, which we need to get to the bottom when we really want to understand this case, this is about having the right to a fair and impartial juror.
You're in your rebuttal time.
I'll reserve the remainder of time for rebuttal. Thank you.
Good morning. May it please the court. Douglas Glade, counsel on behalf of the state of Florida, respondent here. The state submits that the District Court of Appeal here correctly decided this issue fully consistent with established case law from this court and in accord with the appropriate appellate standard of review, which was manifest error, which this court has stated is tantamount to abuse of discretion.
I respectfully, I think that we have seen enough confusion in this area that if we can't do better than just an abuse of discretion, then that's really not telling many people many things. Because it seems to me is that we ought to have some consistency in this area. And if it's almost like what's happened in domestic, other than what's been codified statutorily, it gets to the point that you have no rules of law. You can't even advise anyone because it's whatever comes out of the air, because you can come up with some theory that, some person of a reasonable person could come to this conclusion. Counsel has suggested that there's 2 types of these cases. Do you see that kind of circumstance existing in our jurisprudence? That there are some cases that really rehabilitation is not designed for, whether it's the state or defense, and other cases where where rehabilitation or a discussion needs to be had with a juror. Do you see that, or you think there's no such thing as you look at the law in this area?
No, Your Honor. Each case, it depends on the facts of each case. These are fact-specific cases.
I've got a problem with that. There's no stability in the law if it's whatever whim comes up whatever day.
Well, Judge, I think the abuse of discretion.
That's what I'm concerned with.
No, I think the abuse of discretion standard has served the appellate courts well.
I respectfully disagree with that, because I've been doing this almost over 40 years now, and I can find a case somewhere from an appellate court on identical facts that one time will affirm and one time will reverse. And it just seems to me is that our trial judges, our trial lawyers, Floridians, deserve a little more stability in this area. Maybe I'm wrong. Maybe I'm just absolutely wrong.
No, if I can help you out a little bit.
That's what I'm trying.
I think that what I've noticed in the law is where there is a fixed opinion. If you look at the cases that were cited for conflict here, Singer, Hamilton, Overton, each of those cases you'll see it's like a fixed opinion as to guilt, fixed opinion about the defendant's case because they read prior TV, newspaper.
Okay, all right, I accept that.
So what we have is an abiding state of equivocation, if you will.
Well, does it make a difference when you say fixed opinion? I can accept that.
Correct.
Does it make a difference as to what that fixed opinion is based on? He suggested that some things are based upon misconceptions. That people really don't understand our death penalty statute, and they may make what appears to be a fixed statement. I'm against the death penalty.
Correct.
But they don't understand, or I'm in favor of it. Yet it can't be imposed just because there's a murder conviction. You see what I'm saying?
Yes, Your Honor.
So that's
it does make a difference.
So how would you describe that difference as to when it comes down to what the fixed opinion is based on? Does that make a difference? Or should it make a difference? Let me say that in the law.
I think what I'm saying, it's tough because there's so many different facts and so many different things that a juror can say. We don't know what a juror can say. I think that's why we have to give discretion. I'm sorry.
What else needs to be said when you have a juror telling you, this is a burglary case, I just found that out. When I was 8, somebody broke into my house, stole my Christmas gifts, and I can't be fair in a burglary case. I mean, why can't the judge have said, cause, goodbye, let's bring somebody else? Why is there a need to rehabilitate that juror? And let me talk about the rehabilitation. The rehabilitation here was done by the judge. I got to tell you, my wife was a juror earlier this year, Palm Beach County. And her and I have been married since I got out of law school. She's been with me throughout my entire career. She knows all the judges. She's watched trials. She's familiar with the courthouse setting. She's not a lawyer. And the judge in a particular case is a personal friend. So if anyone should be comfortable in that courtroom, you will be my wife. Now you have someone who's not a lawyer, who doesn't have that kind of familiarity with the courtroom and the judge, regular person from the street, comes in as a juror. And there's this guy wearing the robe, and she's there with a panel of 30 people. And the judge is telling her, leading her into believing, in this particular case, pretty much leading her into being fair, talking her into being fair. I mean, what do you think a juror is going to say? Well, yes, of course, Judge, I can follow the law. And that's supposed to be determined?
But Judge, I don't think that's what happened here, though. If you
I'm looking at it.
We have. If you look at the whole, but the second day, Judge, all we have on the second day is a total positive, unqualified answers by the juror.
Was there a dearth of jurors there or something? I mean, why do we have to go another day to determine whether or not one juror should be excused for cause?
Well, Your Honor, I think that's just how it happened. If you see Juror Sabalos, her first time in answering the question was on page 155 of the transcript, which is like later in the day, and then it just so happened that they were recessing for the night, and then she came back the next morning. It's just the way the timing went, But
I just have a. Again, having been a trial judge for a long time, I've always had interpretations with this whole idea that a person can say all these things and raise all these concerns about fairness and how he or she could be fair or not. Suddenly, because after defense lawyer and perhaps even the judge get out, or the prosecutor and the judge, depending on which side the jury is talking brought to her or him, and suddenly the juror says, "Okay, yeah, I can follow the law. Yes, I can be fair," and that's supposed to be the end of it. We're supposed to disregard everything else. I just don't know that we're actually getting the type of jurors that should be sitting on these cases.
Well, Judge, I think we have to leave the discretion with the trial courts, and obviously the trial judges, they have, under the Conde decision, Your Honors decided, you said that honors have great discretion and manifest error. It seems like there's a extra discretion being vested in the trial courts when it comes to cause challenges.
Isn't that ultimately because, at least to the extent that the juror ultimately professes an ability to be unbiased, that it's a credibility determination that the trial court is making about that ultimate profession of a lack of bias. Now, I understand why people might be skeptical about that in the context where someone starts off, comes out the gate saying, "I'm going to be biased." But it seems like that, if anything, that would point to some kind of rules about certain circumstances that actually preclude any attempt to rehabilitate the witness. You just kind of cut it off. If you say something that falls in a certain category, you get cut off, and so the judge isn't then called on to make a credibility determination. I think we must presume that the trial judge here was convinced, based on the whole sequence of events, that this juror could and would be fair. I mean, the trial judge doesn't want an unfair juror. But in allowing the rehabilitation, that we get the trial judge in that kind of situation. If you have some response to that, I invite you.
Well, Your Honors, the cases do, to follow up, the cases do suggest that a judge should inquire. The cases say, there's no case that says the judge has to stop and just excuse.
I understand that, but based on some of the concerns here, I wonder if what do you think that is an adequate framework, or could there be some advantage to having some rules about certain types of statements that are categorically the end of the discussion? Now, if you think that's a bad idea, tell me. I'm not saying. No, I'm not. Don't misunderstand me. I'm not saying I necessarily think that's the way to go, but I've heard some suggestions that maybe that would be the way to go, and I wonder what you think about that.
Well, Judge, this is not the case. I mean, what was said here by this juror as a crime victim, she was somewhat educated, as jurors are, in the jury selection process about her role as far as the presumption of innocence. And a lot of jurors don't know coming in. They don't really know the system about what the burdens are. They're hit with all this.
But that's not the issue in this case, whether she understood legally what she was supposed to do. What really is of concern to me is that it's what the prosecutor did here. And after she said any number of times that she could not be fair because of the burglary that had taken place in her life, when the prosecutor gets up, the prosecutor starts asking her a series of questions about whether if she could keep an open mind and listen to the law, and then she ended up saying, "Yes, I think I could." Well, then the prosecutor goes back and says, "Well, you can't say I think." He says specifically, correct. You can't say I think. And so what does she do? She turns around and then says, "Yes," without the "I think I could." That just seems to me that she's been led into making this kind of statement. Despite all the deference and everything that you might want to give a trial judge, how in the world do you have confidence that this is what she really feels after she's told that she's got to take the qualifying, in essence, she's told, you got to take that qualifying language away from that answer?
Well, Judge, I think we have to look at other statements she made, and the fact that defense, even in response to defense counsel's questions, she said that she knew I know I can do it. And
this is after the defense counsel's questions, or after the state has already told her what she needs to say, correct?
Well, Judge, I think just overall...
I'm asking you, isn't that the case? Defense counsel's question comes after the state has told her, in essence, you can't put any qualifiers on your yes.
Well, Judge, no, I don't think that exactly happened like that. And the most important thing is on the second day, she makes unqualified responses to the state's questions. And the most important thing, which doesn't show any kind of leading or suggestive answer, is... This
is the day after she's already told no qualifiers.
Well, but this question doesn't really lend itself for that kind of answer, because defense counsel, in the context it was asked, defense counsel merely asked her, as we are sitting here today, have you been thinking about what we talked about yesterday? It was just an open-ended question, non-leading, and this juror volunteered, totally on her own, made this statement. And I've talked about it, and I have more open mind about it, and I gave a thought, and I have open mind, and that anything that happened to me in the past has nothing to do with this case. This was based upon reflection. It was not based upon her embarrassment, and the trial court found that. In its order, I cite on page 2 of my brief, I quote from the trial court's ruling on the cause challenge, and the judge, it says, based on her demeanor, I believe from reflection, and it does. The judge also mentions that she thinks she was embarrassed, but even if she was somewhat embarrassed, that doesn't make it any less truthful and candid and sincere.
I have a really strong concern about that statement, because if anything, we ought not have, whether it's in favor of a defendant or in favor of the state, someone being ashamed or embarrassed into answering the way a court or a lawyer wants them to answer. My concern is, how do we eliminate or assure ourselves that it's not the product of shame or embarrassment? That's what it seems to me ought to be the standard. And Justice Kennedy makes some wonderful points on, maybe we can't, get to a really an ideal. Maybe we're as good as we can be now. But I'm really troubled about a system of justice that's based upon those who decide being shamed or embarrassed into being able to sit. That to me is problematic. I would like, if you could help me find a way that I would rest comfortably at night, knowing that we're not shaming or embarrassing people into what they don't believe just to verbalize it to sit on a jury. Because this cuts both ways, my friend. I mean, this is. The state's going to be as impacted by this, and that same rule of law is going to have to apply with regard to the state as it would to any defense counsel raising an issue on this. You can get a person that I can give you a hypothetical that would curl your hair, and you'd have to let that person sit, even though they despise the state, they would consider themselves a sovereign citizen, not bound by anything. But oh yeah, I can be fair. That there's something wrong with the system. That's the best we can do. Right? I'm searching for your help to help me find. Well, I'm trying to everybody.
Judge, I do think that what the state what we have is a good system as far as the abuse of discretion and all the case law. Speaking of manifest error and the giving deference to the trial court, as to the reasonable doubt standard that defense is espousing here, it's really not for appeal. I mean, that's basically what the defense is saying here, that the appellate court should use a reasonable doubt standard, and that's left more appropriately for the trial judge. That's what the case of Singer, what Your Honors decided in Singer. You directed that language to the trial judge, that if the trial judge has any reasonable doubt about a juror's competency, then that answers Judge Labarga's question. If this judge had any reasonable doubt about Juror Sabalis,
it's really interesting that you mentioned that, because like in federal court, this juror would have been gone, because typically defense counsels or prosecutors don't get to question jurors in voir dire. One of my good friends is a federal judge, and he's a nice one. He gives each side 15 minutes for voir dire. So this juror said to the federal judge in the case, and I'm quoting, "I don't think I could be fair against Mr. Matarranz because I hold that grudge." That juror would have been gone.
Well, that's
and somehow, justice is done in federal court. It just seems to me, counsel, and I know you're doing a great job, and This is a tough issue, and we're all engaged in this, and I don't want you to think that we're picking on you. I do want to discuss this, but it just seems to me that at the very beginning, when Ms. Ceballos said, I don't think I could be fair against Mr. Matarranz because I hold that grudge, I just don't know where you can go from there, other than talk her into being fair. I just don't know where you can go from there. And that's the concern I think all of us have. Where are we going to embarrass somebody, or she's going to feel bad, or she's going to hear the rest of the jurors say, yeah, I could be fair, and she's going to be in that situation where she's going to say something she doesn't really mean.
Judge, all I can say, I think we have to follow our case law. I think, and what our case law says is
but
that
again,
there should be an inquiry.
It looks like our case law is going lots of different ways. And that's I was hoping maybe out of this one that maybe we could find some stability. Maybe we can't. Maybe that we're just as good as we can be. But our society places great value on the virtue of being non-biased. Great validity on that. And to force someone in the presence of 50 or 60 other people to not give in to that, to me, it's almost beyond human reason. I just don't understand when a man such as yourself would stand up and said, I can't be fair because my child was murdered. And then after someone browbeating you, which is tantamount to making you become embarrassed that you ought to be a fair person, is why your statement at the end of the day, oh, yes, I could be fair, is more truly represents what you think than your first statement. That was your response to it, who you are response. So
Judge, I think we have to give discretion to the trial judge who did, I believe, a good job here as far as saying that, and she viewed the demeanor. She said this was based on reflection. This is not based on embarrassment. That's what basically the trial judge, if you read the ruling, the trial judge held here. It's not for us at the appellate level now to say she was embarrassed, and that's why she testified or gave her statements as she did. That's for the trial judge. The trial judge can look at sarcasm, which we don't, in the cold black record, can't see sarcasm. We can't see a lot of different things, embarrassment. And that's why for this unique area, when you're talking about lay people were questioning jurors.
I think one of the problems is we would have never gotten to that second day if we had some kind of rule that, such as Justice Labarga may be suggesting, that if a juror definitively states their bias based on some experience that they've had in their life, if we excuse them for cause at that point, we would have never gotten to the second day, whether she was reflecting or whether she was embarrassed or whatever, would never even become a question because she would have not been there at the second day.
Yes, I understand. I just think the state feels it would be too quick. It's just too, I mean, a lot of jurors, I've tried cases, like I say, Judge Lewis, you mentioned about trying cases, and I've tried over 50 jury trials, and almost everybody, there's lots of crime victims, and and I'm sure Justice Labarga, I'm sorry, and all a juror has to say is, I can't be fair. Just go, basically, I'm a crime victim, or
and also we have to
eliminate.
I mean, I'm cognizant of the fact that whatever we rule in this case, it may also, go right into the civil area. And if you think Bo Dyer are lengthy and complicated and detailed in criminal cases, even in homicide cases, you ought to see a medical malpractice case. I mean, they go on I had one that went on for a week, and I've gone through like 400 jurors because lawyers asking these kind of questions. So whatever we say here today translates into that field as well. So we have to cognizant of that fact.
But is this court aptly instructed in the Trotter case regarding appellate review? On appeal, the question is not whether a reviewing court might disagree with the trial court's findings, but whether those findings are fairly supported by the record. And that principle has been repeatedly stated by this court. And the findings, the trial court's ruling is supported by reasonable findings and facts in the record. So therefore, the state would ask that this court not disturb the District Court of Appeals ruling. Thank you.
Thank you.
try to speak fast because this is an interesting issue going in both directions. First of all, the 4th District Court of Appeals in the case of Montozzi, there Justice Farmer proposed to do exactly what this court is doing. There are certain comments made by jurors that there is no rehabilitation. What's remarkable about this case, this is the perfect case because it all comes together in this case. We, number one, see a juror saying at the beginning, I can't be fair, I can't be fair, I can't be fair, pointing to a defendant that I'll hold my judgment against him. You then have a prosecutor. Now the rehabilitation starts. And keep in mind what this court held over close to 100 years ago in Johnson v. Reynolds. You have to be really suspect of rehabilitation, the last response. But what happens in this case? The prosecutor tells the juror, you are not allowed to lean. It was only after the prosecutor tells the juror that she was not allowed to lean was the first time, at any time, did this juror indicate that she can be fair. And what is our position is this juror was allowed to lean. She had every right to lean. She came in court and she was telling everybody the truth. I can't be a fair juror in this case. So number one, we would take the position that in certain cases, when a juror says she can't be fair, there is no rehabilitation.
Be careful what you ask for. You know,
it may go the other way.
In many instances, you got people who come in and says, my nephew was arrested, and I don't think I could be fair to the state. That would be the same.
But if the court's looking for a bright line rule, the line gets drawn when we're talking about emotional responses from a jury as compared to legal analysis. However, if the court wants to keep the old law, which it would work in this case equally the same, because what this court has far back as Singer, two basic concepts. Closed cases must be resolved in favor of the defendant. And two, if there's any reasonable doubt about a juror's ability to be fair and impartial, they must be stricken for cause, and that's manifest error. Why did this court hold that? Because back in Singer v. State, this court recognized there's something wrong if a court of appeals can allow a juror like this to serve on a jury. This juror said she can't be fair 6 separate times. How could any person have any confidence in the criminal justice system if a juror like this is allowed to serve on a jury?
Before you finish, would you respond to Justice Kennedy's question, which was a great question, before you sit down? Do you recall what he was asking?
I think what Justice Kennedy was getting to is, are there certain times where there should be no rehabilitation? And I would submit...
No, I don't think that's what... I mean, he was saying is that you have this discretion that has to be imposed, that you've got the overlaying view of a judge, determining credibility, and in other areas of the law, that we allow room for that trial judge to make some of those decisions, and then the appellate standard is not one of micromanaging what happens.
Correct. And I think what this court in Hayes... I think that was half of the question, and the other part of the question is how do we allow discretion, how do we create a rule that allows discretion but prevents what happened in this case? Because it's our position that if a rule allows what happens in this case, the rule's not working. And this court in Hayes v. State has specifically held that just because a judge has discretion doesn't mean an appellate court can't review that discretion. And so if I was forced to give a rule...
When we review it, though, it's the question we ask ourselves, whether we would have a reasonable doubt about the ability of the juror to serve, or the question we would ask in our appellate review function, whether any reasonable judge could decide...
A reasonable doubt.
Beyond a reasonable doubt that this could be a fair juror.
And I know I'm out of time, and I think the easiest way to describe that is if this court goes back to the Overton case. It's a case where a juror back and forth changes his mind back and forth, and this court reverses. All during the Overton case, the juror said, I will give the defendant a fair trial. I would testify if it was up to me, but I would give the defendant a fair trial. Under the 3rd District's analysis, if it's allowed to stand today, you pick and choose 4 times. The juror said, I will give the defendant a fair trial. If there's something in the record where the juror says, I give a defendant a fair trial, under the 3rd District's analysis, the game's over. If that was the analysis in Overton, Overton would have lost, because at the end, Overton said, I will give the defendant a fair trial. This court looked at all of the circumstances. And in this case, when the court looks at all of the circumstances, there is no court anywhere that could have concluded that this juror could have been fair and impartial. She told everybody she can't. She was the only one who said, I know myself. I can't be fair. How could any other court look to, what are we to say, you weren't telling the truth? This juror was not a fair and impartial juror, and it is our contention that this court, number one, should consider creating law that prevents jurors from being rehabilitated when they say they can't be fair. Thank you.
Thank you for your arguments. Court is adjourned.
All rise.
You're watching the Florida Channel, a public service of the Florida Legislature, WFSU-TV, and Florida State University.